This week on Lewis on the Law, I have yet another empowering and informative show for you. I have attorney Fancis Dixson on with me, and we're going to talk about the trial and the appeal. Welcome to Lewis on the Law. You are listening to Lewis on the Law, and I have yet another empowering and informative show for you today. I have attorney Fancis Dixson on with me from the Dixson Law Firm, Dixson Law LLC. Got to get these right. There's so many tricky nuances to legal firm names. And it is great to have you on. I'm just going to let everybody know that we're not going to talk about it too much. Attorney Dixson here has just argued a case in front of the Georgia Supreme Court, so that's a big deal. How are you today?
I'm great, Lewis. Thanks for having me on.
Yeah. So today what we're going to talk about is the trial and the appeal. So where do we start here?
So, you got to go back to the very beginning whenever you're going to discuss this in a way that people can really break it down and understand it. You know, you want to go back to sort of where...
So you start from the beginning and then you go to the end.
Absolutely.
Got it. Okay, so what is the beginning?
It's going to be, when you have a dispute, you have some sort of conflict that arises in your everyday life that escalates.
Mm-hmm.
And tensions escalate, a fight breaks out, and one party irrevocably says something like, I'm going to sue you.
Ouch.
So
the things neighbors never want to hear.
Right. And a lot of the times, that's just going to be hot air. But sometimes, and that's the reason you and I have a job, is it's not just hot air. It's something that somebody wants to follow through on. They want to figure out exactly how they can have their day in court, so to speak, and what that process looks like.
Okay, so the lawsuit, that's what the lawsuit is. It's basically, a kid squabble that's grown too much and can't be resolved. So are there differences between a civil and a criminal lawsuit or a case or filing?
Yeah, absolutely, right? Because when you're dealing with a criminal case, what you're basically dealing with is the state taking it upon itself to enforce its own laws. And that's not what you have when you're dealing with a civil suit. The civil suit, it's just like what we're talking about. And again, I think most people involved in litigation would take it very seriously, but it's just sort of an analog. It is very easy to break it down into a squabble, right? Some sort of dispute, some sort of fight, and just about anyone's had experience, either firsthand or secondhand, with seeing two kids, in the back seat argue over something. So
yeah, exactly. So we're talking about suing. What does it mean to sue?
So generally, what you're dealing with is a lot of paperwork, and that's something that people get
Paper publishers.
Absolutely, right. It can freak you out because you don't know what to file or where to file it. And some people take it on themselves to get the best information they can off the internet, or, the rare breed who goes to a law library or a regular library and tries to actually dig through the books for the answers they need and ends up at the courthouse with the paperwork filled out and tries to proceed with the lawsuit.
Okay, so you are a trial attorney, and that differs from someone like me who does predominantly transactional, though I do some trial work. I think when it gets into heavy lifting, I usually bring someone in to assist me to assist me with the actual nuts and bolts of a trial. But you're a trial attorney, so what are people looking for when they're looking for a trial attorney? When it all breaks down, when it looks like there's nothing left to do except for go in front of a judge and jury.
Absolutely. I've been endeavoring for the past few years to be a real trial specialist, to specialize in trials and appeals. And what that looks like is being the guy that you call when, you're used to settling and don't know what the courtroom entails or how to structure your case so that it can be persuasive to the trier of fact. What happens frequently with lawsuits, especially in this day and age, is they settle, right? Mm-hmm. Statistics are playing a big part of that ever since Moneyball. Statistics have pervaded pretty much every industry, and the law is no exception. What you get is similar types of cases with similar facts coming up, and the more information that's gathered on that, the more statistics that are developed, the more confident attorneys can be in negotiations and in settlement discussions.
Yeah, it almost always, once push comes to shove, people always like to settle because I don't know anybody who really wants to go in front of, spend, a week going in front of a judge and jury.
Right, and see, that's the sort of thing that makes lawyers like me who do enjoy that the exception.
Yeah, and you guys can make a lot of money, I know. So before you file a lawsuit, are there steps you can take? Is there some way you can get some sort of resolution before all this actually gets to the filing point?
Oh, absolutely. I mean, resolving a dispute is as basic as it gets, right? All you have to do is get some sort of middle ground between you and the adverse party, and basically reach a compromise. Because that's all settlement is. Once you've engaged in a lawsuit and you've spent a bunch of money on the legal battle, a settlement's just a compromise. So if you can reach a compromise before you even get to the point where you need to go to the court, you're going to be better off.
So is that your process? You just basically call up the other attorney and say, hey, let's reach a settlement? I mean, I want to get into what the process is here.
Sure, yeah. I mean, and that can be, right? Like if you're dealing with, let's say before attorneys even get involved, you've got two people who are just in a dispute, right? They're going to want to send written communications to each other, where they're going to want to try and outline their sides of it. And, cooler heads prevail more often than not. Once you've got a written statement in front of you saying, here's my grievance, here's my issue, you're sort of put in a position where you either need to respond directly to those or not respond to those, whether it's by being silent or sort of trying to change the subject, something evasive. But it puts you on the point, right? And that carries through all the way. That carries through all the way from when the initial fight breaks out all the way down the line to the day before trial.
Got it. So let's get into filing a lawsuit. What actually happens here? What are your first steps?
So you're going to be dealing with pleadings, right? So the forms we talked about a little bit ago generally break down to what we call a complaint. You put together a statement of the parties that are involved, why the court that you're filing in has proper jurisdiction, and then you're going to break down into the counts of your claim. You're going to say, I'm suing this guy for breach of contract, or I'm suing this guy for conversion, and separate each one of those out and sort of state the elements of the claim before you end it with your prayer for relief, and you tell the court what you're asking for.
Which is a lot of money usually, right?
It certainly can be. Sometimes you're looking for equitable remedies like injunctive relief to get a ruling from the court that so-and-so has to stop whatever they're doing.
Now, do people bring counterclaims at this exact same time?
So no, the counterclaims are going to come in the responsive filing or the responsive pleading, which is usually referred to as the answer. And generally in 99% of the situations, you're going to have about a month to respond to that complaint with an answer. And that complaint has to be properly served upon you before that clock starts ticking.
And what does a counterclaim usually consist of? Is it also a demand? You basically state a second complaint, a complaint against them, and then go ahead and ask for relief once again?
Right. So a counterclaim is going to be a response that includes your own claims for relief, right? It says, hey, not only are they wrong about what they're saying about me or what they're saying about the situation, and should they not get what they're asking for, but I've been harmed. And I should get something out of this because of what they've done to me.
Now, when you said equitable relief, what do you mean? We want to break this stuff down for our listeners out there. I get some calls from ordinary people, and when you start saying equitable relief, they're like, "What does that mean?"
Right? Yeah, and it's a common question because a lot of the times, what you see on a business card or a billboard is attorney at law, right? And it's difficult to understand that comes from. And again, I'm not a legal scholar, but at some point in the past, there were separated into law and equity. And nowadays, equitable relief's limited to basically the superior court on the state level, right? When you're in magistrate court, you can't get a ruling from the court that orders someone to do something, right?
So equitable relief is when you get the courts to order someone to do something. Is that the way I'm hearing it?
Right. It's when the court basically steps in and impairs or grants extra rights, right? Because what we do is we've got an established set of rights that each person is entitled to in this country. And in order to remove or curtail those rights, there has to be what we call due process. And so generally the court tries to avoid doing that. And, monetary damages, the reason money is so frequently the subject of these lawsuits is because there are very few things in the modern world and in our capitalist society that can't be quantified and can't be monetized.
You're listening to Lewis on the Law. Francis, I think we're at the end of this segment, so why don't you give them some contact information for you real quickly?
Okay. I could be reached at 678-214-7700 or by email at Francis, Francis, at DixonLaw.com, DIXSONLAW. .com.
You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week for the next 48 minutes or so. I think we've already used 12. All my old shows are archived on my website, so you can go ahead and contact me at James, or you can go to jameslewislegal.com, check out my video blogs, check out my podcast. Everything's archived there. Eventually, every single legal issue you can think of will be archived on my website. So this show is designed to empower you, the listener, with legal information. It's designed to help you take your first step in any legal issue. You can find what to look for, what type of attorney you want to look for, if you have a case at all. This show will help you steer you in the right direction. If you have a serious legal issue, don't rely on the advice that you hear on this show. Go ahead and contract with an attorney. This show is designed only to give you information. That's right. We want to give you information to empower you, but to actually handle a serious legal issue, if you've discovered that you have one, then go ahead and contract with an attorney. You can always contact me at jameslewislegal.com or you can give me a call at 404-610-0075. When we get back, we're going to look into discovery and the trial itself. You are listening to Lewis on the Law. My name is James Lewis, and I have yet another empowering and informative show for you today, because what we're talking about today really impacts you in case everything breaks down. Negotiations break down, conversation breaks down, tempers flare, and you find yourself ready to go into court. Now, when we left off, we were talking about pleadings. Let's talk about discovery a little bit. First, what is discovery?
Right. So once you've got a lawsuit initiated, depending on which court you're in, but most are going to give you discovery powers, and they're going to give you the ability to, once the answer has been submitted to the court, request information from the other side that will help you clarify the facts, help you clarify the witnesses, and get a better understanding and a whole picture of what the case is going to look like when you get to trial.
Okay, so does discovery entail anything? Do you have to do anything to get discovery?
Absolutely. There are all sorts of written procedures that you can follow that are, codified in the statutes. You can send requests for documents. You can send interrogatories, which are just questions to the other side that they have to send you written responses to. There are a number of functions available.
Okay, can you ask for anything in discovery? Can you ask what the attorney has been talking to the client about and get that? How about email records between the attorney and the client?
Right. So, of course, attorney-client communications are going to be confidential. And there are some other types of privileged conversations and communications.
So you can't just get anything. Because that would be great. I mean, if I could get, what has the attorney and the client been talking about? Because that might give you some leeway into a really good strategy.
Sure. And that sort of strategy discussion is protected exactly for that reason. Because if that was discoverable or obtainable, then there's no real benefit to having an attorney. Right? Because if any of the strategy that they give you is going to be something that can then just be turned around and given to the trier of fact, like a jury, it's going to create a level of transparency that sort of removes any ability to strategize at all. That
makes perfect sense. Now, I forgot to introduce you. Of course, this show, we're talking about the trial and the appeal process. And I have attorney Fancis Dixson on with me. And I brought you on because you've recently argued a case in front of the Supreme Court, or the Georgia Supreme Court. And I find that really fascinating. Not just everybody does that. But let's get into trial prep here a little bit. What do you have to do to prep yourself for trial? Because that's what we really want to get into.
Yeah, I mean, what you're going to have to do when you're prepping for trial is start as soon as you get onto a case, right? Mm-hmm. I mean, at least that's how I look at it. Because, again, I get brought in a lot of these cases after settlement negotiations have broken down.
So you're not brought in initially during the whole negotiation process. Someone sends a demand notice, someone else says, heck no, I'm not giving in with that. And then someone files a complaint, then someone countersues. You're not part of all that process, right?
No, and I mean, I certainly do that in my practice. I generally get handed cases that are more complex and wrapped up in and on themselves that I have to untangle. But generally, aside from those sort of complex cases that attorneys just don't practice in, most attorneys have practices built around a certain type of case. And so they'll get used to being able to follow the law and have a very deep understanding of it and argue those cases better than someone like me who's kind of a generalist can. What happens, though, is you get into a volume practice where you've got all of these cases coming in and you get aggressive about settling them, and you're settling them pretty consistently because you know what they're worth. But every now and then you're going to have a situation where, because of just one reason or another, settlement negotiations break down, whether it's bad blood between the parties or someone's not being rational on the other side. And in that situation, you're dealing with somebody who's got a volume practice built on, this particular type of case, who hasn't had to litigate it because of the statistical evidence that's built up and the fact that in 99% of the situations, there's a rational reason to compromise.
That makes complete sense. So you can't get this compromise going. Do you always just go in front of a jury?
Yeah, I like to get in front of a jury when I can, because that's where you're going to get, more often than not, a fair shake.
But isn't that also more often than not where you may get a judgment that may or may not be predictable?
Right. I mean, anytime you go into the courtroom, I like to tell clients that it's like going into a boxing ring. Right. You can be as in shape as you can get. You can be the best shape of your life. You can be as prepared as you can be. You can have watched all the tapes of the other fighter. You can have done all the research and road work and training that you can. And you still can't account for, sort of unpredictable variables. Right. You can't account for the one punch really ringing your bell and sending you to the mat early, or the judge seeing something the wrong way and calling the fight incorrectly.
So is there an option here to go in front of a judge or a jury? And what are the benefits of going in front of a judge versus going in front of a jury?
Yeah, generally you've got what's called the option of going to a bench trial or a jury trial, right?
Mm-hmm.
And that depends, again, on case specifics, but more often than not, both are available for serious litigation.
And they're available for both sides. Both sides have that option, or can one side force a jury trial?
So either side really can demand a jury trial, right? Usually it is up to either party whose rights are at stake. So as we were talking about counterclaims before, once you've got counterclaims involved, both sides have claims that they are seeking to prove, and then either party can really demand a jury trial at that point.
Now, is there ever a benefit going in front of just a judge instead of a jury?
Absolutely. If you think your case is law intensive and the facts are pretty straightforward, the problem with a jury trial is that the judge is prohibited from acting as a fact finder in that situation. So the judge can't make a determination about the facts. They have to leave that up to the jury. So if you're on a case where you think it's going to turn on the law and the facts are pretty clear cut, you might prefer to have the judge, who of course has a little more experience with the law than your average juror and a deeper understanding of that law, make that call.
And the judge also becomes the fact finder in a bench trial.
Exactly. So because they become the fact finder, they can make a determination that's kind of merged between the law and the fact. And when you have a jury trial, you take that ability out of their hands. They're allowed to instruct the jury as to the law, but it's ultimately the jury that's going to have to decide how that law is applied to the facts at hand, and because they're the ones that have to decide the facts.
Excellent. So let's get back to the jury. So how does the jury selection process go down?
And that's a great question, because that's something that a lot of people just aren't familiar with unless you get a jury notice. So what generally happens is you're going to get one of these things in the mail from the county of your residence that says, hey, you've been, your name came up in the jury summons lottery, and we need you to show up at the courthouse after you fill out this questionnaire 2 months from now. And so you'll fill out the questionnaire, you'll contact the court, get whatever information that they need, and show up at the courthouse and be herded into a room with a bunch of other people from your county that don't want to be there and on a weekday, and have to watch about an hour-long videos on what it means to be a juror and how all of this process works. Once they've been educated, and usually that's also because in the courtrooms what's going on is the judge is kind of doing any last checks, any final motions between the attorneys, asking what's going on with the case, if there's any last-minute chance of settling. Because, of course, once you start the jury selection process, you're starting to undertake a lot of work that a settlement could completely avoid.
Excellent. And so out of this pool of people, do they just stand up and some volunteer and say, hey, I want to be on the jury, and other people are like, I don't? What if everybody says they don't want to be on the jury?
Right. So generally, it's just not a question that's given to them, right? What happens is you're in this room, and after you've been in there a little while, somebody comes in, they call your name, they call 30 names, and the 30 of you go out and get herded into a courtroom. And then you're in a courtroom. The judge will give you a little bit of a spiel about, sort of the base information needed to understand what the case is about, ask you some very general questions, and then the attorneys that are in the room are going to ask you some follow-ups that sort of pin down, what they're looking for in that situation is they're looking for any hint of bias. They're looking for anything that would make your ability to be objective and to just look at the facts and nothing but the facts wrong.
And so is it the attorney that are kind of like picking teams? Let's see. I like that guy. He looks like he's going to be easy on my client. I'm going to pick him. Or is it like picking teams, on the school ground, playground? You're like, I like that guy. He looks like he can shoot a basket.
It's not, but it can certainly feel like it sometimes because what you're dealing with is an adversarial system that's designed to get to an objective juror. And the way to get there is to remove the ones that are obviously problematic. But you're limited.
You get a couple of strikes. That guy, I know he took one look at my client and he said that guy is in the wrong. So you want to scratch that guy. Is that the way it works?
The way it works is both sides are going to get the ability to strike people for cause, and then they have a limited amount of strikes that allow them to remove people without having to give a reason, basically. Right, and so when you're getting into voir dire, what we call voir dire, but it's just jury questioning, right? What you're getting into is you're trying to identify people who might have an inherent bias towards your case, or who will be favorably viewing your facts from the get-go, right? And certainly you can get an impartial jury, but you can't get a robot jury. There's always
can't get a robot jury?
As much as you might want to, there's always going to be some inherent bias there. There's always going to be the human element that you have to take into account.
I think the robot jury is on its way. You're listening to Lewis on the Law. Francis, we're at the end of this segment. Give them some contact information for you.
Again, I'm Francis at Dixson Law LLC. You can reach me at francis@dixonlaw.com, FRANCIS at DIXSONLAW.com, or call my office at 678-214-7700.
You're listening to Lewis on the Law. My name is James Lewis. If you have a topic you'd like to hear on this show, go ahead and drop me a line on my email or on my webpage, jameslewislegal.com, or email me at james@jameslewislegal.com, and I will try and bring an attorney on who actually knows something about your case. You can also give me a call at 404-610-0075, and if I can't help you, I can direct you towards an attorney who can. You're listening to Lewis on the Law. You are listening to Lewis on the Law. My name is James Lewis, and I have yet another empowering and informative show for you going, which we're talking about the trial and the appeal process. I have attorney Fancis Dixson on with me from Dixson Law LLC. Francis, give them some contact information for you once again.
So again, I can be reached at francis@dixonlaw.com, FRANCIS at DIXSONLAW.com, or by phone 678-214-7700.
You're listening to Lewis on the Law. My name is James Lewis, and I am your host. If you have a topic you'd like to hear on this show, go ahead and contact me at jameslewislegal.com. On the very last page of my website, there's a contact page. You can drop me a line, just kind of describe what you'd like to hear. And if I don't know enough about your topic, I will bring an attorney on who does know enough about your topic, and we'll talk about it on air. It may take about a month and a half for me to get around to it. Believe it or not, I'm booked all the way up until May right now. So I've got a lot going on, but we'll still get your topic. I love hearing from you guys. This show is designed to give you legal information. So if you have a serious legal issue, don't rely on what you hear on this show to handle it. Don't listen to Francis and say, you know what, I'm going to file a complaint right now, or wait a minute, I just got served notice. I know what to do. I'm going to file a counterclaim. I'm going to handle this. Don't do that. Go ahead and contract with an attorney. Don't rely on what you hear on this show. This show is only designed to bring you information. If you have a serious legal issue, contact an attorney. You can always contact me. I'm an attorney. If I can't help you with your issue, I can direct you towards an attorney who can. A lot of these attorneys come on my show, so we're pretty well connected here. Francis, when we left off, we were talking about the trial itself. Now, trials get really expensive, don't they?
They certainly can. And, a lot of times you're going to get a client who kind of balks at that, right?
Mm-hmm.
And that's a big motivator for settlement is the litigation cost. But what gets complex about that is the fact that oftentimes the litigation cost is really outside that attorney's control. Right. I mean, you're going to
because they can go on for days, and all of a sudden, you're paying the guy $200 an hour, $300 an hour. Some attorneys get paid $500 an hour.
Yeah, I mean, absolutely, and especially at those sort of big blue chip firms, it can really get up there fast. But oftentimes, it's worth it. Right. What you're fighting over is important enough to the parties involved that that's a drop in the bucket. What gets tricky though is the fact that an attorney in any given sort of litigative scenario is only going to have control and authority over his client's side of the case, right? There's always going to be adverse parties who are doing their own thing and making their own demands, sending their own discovery, and there's going to be the judge who's acting unilaterally to try and keep the system efficient and well-oiled and moving along. So there can be a number of things that just pop up that you have to react to, even when you're the plaintiff. So it just gets tricky very quickly.
Yeah, I think a lot of people would try and avoid that. So once you get past the jury trial, is there a process, evidence? Let's talk a little bit about evidence, witnesses, facts. What can you bring in here?
Right. So what you're going to bring in is anything that you can that'll help prove your case, right?
Mm-hmm.
Let's talk about something that's pretty general. Let's just talk about a car accident as a hypothetical that, that the light was green for you and that it was red for the other guy. And so you sue the other guy for causing this accident because he ran a red light. There was no one else to see it but you and him, right? And so you're going to end up in court where you're both trying to substantiate these claims that the light was favorable to you or them. And so, one thing you might try and do is bring in other people who can testify that they were there and saw something that supports your side of the story, right? Oh, I was nearby and looked away 15 seconds earlier and the lights were a certain way. And so the chances of them being the way that the other party is saying they were are very low. And you should believe our guy because of it.
Now, this gets into the exciting part of cases, or at least the exciting part that you see on TV, where Perry Mason or Raymond Burr come in and, they're examining the witness.
Absolutely. And witness examination can get very fascinating very easily, especially when you've got somebody who knows they've done something wrong and is trying to hide it. And a lot of the times that's what you'll see in those TV shows and in those cases is obfuscation at its highest. Mm-hmm. What gets tricky is the amount of preparation that can go into that and and that's what discovery is there for, right? Is so that you can sort of leave no stone unturned and you can get the answers to these things before you get to trial so that at trial you can focus on communicating those answers to the jury, right? A good prepared trial is going to be all about, we already know every answer that's going to come out over the course of this thing. It's just about communicating it to the fact finder.
Okay, so let's talk a little bit more about the examination process. Now, I know I'm going to use the words direct examination and cross-examination. I want you to kind of tell me what the difference is between the two.
Yeah, so direct examination is what happens when your attorney is talking to you or is talking to witnesses that support your case, right? And that's a very, generally that's a very well-produced sort of thing where you've talked with your client thoroughly about it. You've established kind of an organizational structure to what you're going to talk about and when you're going to talk about it so that the witness feels comfortable and can give you the facts without too much issue in a way that communicates those facts clearly to the jury, right? You're really in home territory. You're safe, you're comfortable. The attorney's there supporting the witness and making sure that if the witness says something that isn't clear or isn't direct, that he can go back and kind of clean that up.
And how does that differ from cross-examination?
So in every way, right? Cross-examination is what you see on those shows like Perry Mason, where the attorney on the other side gets up and attacks the witness and tries to get to the heart of why that witness is wrong or what that witness is hiding or what sort of aspects of this witness would lead the jury to change their perspective on what that witness is providing to them.
And when I tell people I'm an attorney, that's what most of the people think that I do. And they're really saddened when I tell them that I write leases all day long or I write purchase and sales agreements. They're like, really? That's what you do?
Yeah, a lot of people are going to have that reaction if their only connection with the legal industry, right, is as somebody who watches it on TV, who watches shows like Suits or Better Call Saul, right?
Which is an awesome show. Love Better Call Saul.
Yeah, and it might not have been a great example because it's one of those ones that is closer to reality than fiction, whereas you get some other shows out there that take a lot of liberties to make it a sort of digestible, episodic of the week format.
Now, can you prepare your witness for cross-examination? Can you get them prepped up and say, this is what their attorney is likely to do to you?
Yeah, absolutely.
I'm getting all dramatic here. I feel like, we're talking about nuts and bolts.
That's a big part of it, is preparing them for the fact that this attorney is going to get in their face and try and put them on uneven footing and get them to say something that they don't want to say. It gets really tricky because even in a situation where you're dealing with a very honest witness who doesn't have anything to hide and doesn't have any bias and doesn't have any other reason to be dodging the ball, so to speak, a good attorney who's prepared and has done their homework can get up there and knock them off their feet and make them say something that will confuse the jury or will confuse the issue or will make their side, their theory of the case, seem more favorable.
So, are there rules to cross-examination? Are there some sort of rules that will limit what a person can do in cross-examination or guidelines?
Yeah, absolutely, right. So, the statutes and both the statutes and the judgments that have followed them do establish pretty clear sort of rules, right, that govern courtroom procedure in its entirety. I think what you might be referring to is earlier we had a conversation and I mentioned Irving Younger's 10 Commandments of Cross-Examination.
Irving Younger's 10 Commandments of Cross-Examination. Wait a minute. Who is Irving Younger?
Irving Younger's a famous trial attorney and lecturer who, back in 1975 was giving this speech, and it's become famous ever since. And it really details sort of the tactics involved with a good cross-examination and the things that you sort of definitely want to avoid in the best situations.
So what are some of these? What are the 10 Commandments of cross-examination?
Right. So the 10 Commandments of cross-examinations are basically guidelines to help you control your cross-examination, help you control what the witness who is adverse to your side of the case, who is adverse to your theory of the case, is going to be saying and how they appear in terms of credibility to the jury. Because, again, the jury's only human, and everything that they say is going to be something that goes into their head and computes down to believe side A or side B.
Okay, this is fascinating. When we get back, I'm going to actually get you to break down what are these commandments of cross-examination. And I guess there's 10 of them, since there are 10 commandments of cross-examination. We're also going to talk about the appeals process, and we're going to go back and kind of outline where we have been. And we're going to try and wrap the whole thing up in the first part of this next segment. Then we're going to get into the 10 Commandments and the appeals process. You're listening to Lewis on the Law. Francis, give them some contact information for you real quickly.
Okay, so I could be reached at francis@dixonlaw.com, FRANCIS @DIXSONLAW.com. I can also be reached by phone at 678-214-7700 or at our website, dixonlaw.com, DIXSONLAW.com.
You're listening to Lewis on the Law. My name is James Lewis, and all my shows are archived on my website. You can go to jameslewislegal.com, and you can go to my video blog page, and you can see a whole slew of shows. on my podcast page. Each and every single show I've ever done is actually contained on my podcast page. And eventually, every single legal issue that you can imagine, there's going to be a lot of them, will eventually be cataloged on my webpage. So you can go there. You've got a legal issue. This show is designed to be your first step in any legal process. It's designed to help you make an informed decision. It's not designed to replace the advice of an attorney. When we get back, we're going to hear more about the trial and the appeal. You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week. And this is our last segment, and today we have been talking about the trial and then, of course, the appeal. We have gotten through a lot of stuff. And before I get into that, let's talk a little bit about you, the listener. If you have an idea or a topic that you want to hear on the show, go ahead and contact me at jameslewislegal.com. You can go ahead and hit me on the last page of my website. It's a contact page. Or you can give me a call at 404-610-0075. Once again, that's 404-610-0075. Or you can email me at james@jameslewislegal.com. And you can tell me a little bit about what you'd like to hear. And if I don't know enough about your topic, I will bring an attorney on and we will talk about your topic on air. Give me a little bit of time because I book up my show kind of far in advance. So then that will also give me time to find an attorney who can actually adequately talk about your topic. So it's good stuff. I'm here for you, the listener. I love hearing from you guys. I love the conversations we have. So go ahead and keep it up. It's good stuff. So we have been through the trial. I'm on with attorney Fancis Dixson. You know, the trial has, you've gotten into a disagreement with your neighbor. You've got an attorney. He sent you a demand notice. You guys have responded to the demand notice. You know, tempers are flaring. You're like, no way. Your neighbor has now filed a complaint, served you. You've had a guy knock on your door, a sheriff, mean-looking dude, and he has handed you a piece of paper and made you sign for it. You have answered. You've answered. You had 30 days to answer. You've answered it. You filed your counterclaim. Things are getting heavy. You've decided to go through a jury rather than a bench trial. Your jury is they just didn't like the shoes you're wearing. I know Francis tells me that can't happen, but I've heard horror stories. So the jury doesn't like the shoes you're wearing. I'm oversimplifying because it's always more than that. We believe in America. We believe in justice, and we believe in the pursuit of what is right. And we know the jury always does what's right and never judges someone on something as superficial as their shoes. But just in case it happens and you have lost your case, it is all over. We are into the appeal process. How are we going from here?
Right. So if you've lost a jury trial, and you don't believe in your case, you believe it's a bad result, it's not a fair result, what you're going to do is you're going to appeal it, right? And so it's just like the corollary of you filing, let's say an HR complaint in your office, that it's built into the system all the way up that when somebody has a grievance, someone has an issue, and it gets decided a certain way by this sort of first blush body, there's a way to review that decision. There's a way to get sort of a second look at it. Because it happens all the time where you get a bad result because of a bad reason, not because of a good reason. Just like you're talking about with the jury, not liking shoes. I mean, and
that's just me being schmucky because it's never that quite that. At least I hope it's never quite that simple.
Well, no, and you and I are both attorneys. We deal with this stuff every day, and we understand that. But certainly to the layperson, it can sound like a slanted system or an unfair system. Because they do hear attorneys talking about it, and attorneys are the only ones with really experience and perspective on it. They hear these people talking about the things that we were just talking about, right? Cross-examination, the way to present an argument, the way to be persuasive to a jury, and they think, oh, well, it's all gamesmanship. But there are a lot of people out there. In fact, the majority of people that get selected for juries are going to be people who take that duty very seriously and understand that it's a tenet of our society and are going to look at it responsibly and are going to do their best to see through all of that and see the facts. And the reason attorneys get focused on things like the gamesmanship of it is because that's all they can really control, right, is the presentation and the persuasiveness of their arguments and their case. At the end of the day, if it's a clear foul, the jury's going to see that. They're going to call it that way. So it's important to make that distinction when we're talking about this between, the attorney perspective and the juror perspective. But if you've got a bad result and you think the jurors were just a little off, or you think something happened at trial that was really a problem, appeal is the way that you try and resolve that problem.
And what is an appeal?
An appeal is going to the next body up, right? It's the equivalent of saying, "Hey, I want to speak to your manager," right? Like let's kick it upstairs and let's get a second look at this, right? And a lot of the times, a lot of the times what you're going to be dealing with is an appellate body that can look at the procedure, can look at what's going on, and can see whether the jury was, improperly given information it shouldn't have had, or limited from information it should have had, or whether there was some procedural issue that affected the way the facts got to the jury and affected their ability to look at those facts clearly.
Okay, so what are we doing here when we're appealing a case?
So generally when we're appealing a case, what we're saying is, hey, something impermissible, something that broke those rules. We were talking about the rules earlier, right? The statutes that govern trial procedure. If those are broken, those exist for a reason. Those exist to sort of make sure that people get treated fairly and that both sides get a fair shake at presenting their arguments to the jury and giving everything they need to.
What do you mean when you're saying they broke the rules? What kind of rules can they break?
It could be any number of things. It could be improperly presenting information about a person that isn't relevant to the issues, but certainly characterizes them like a bad way in front of the jury, can prejudice them is the term we use, so that the jury looks at this person and says, even though they're right, I want to screw them over. Stuff like that, we say no. We cry foul. We say that's not what we're here to do. What we're here to do is stick to the facts and get to a fair adjudication of those facts.
And in the appeal process, you basically just go ahead and file paperwork with the appellate court?
Yeah, generally what you do is you try and resolve the issue at the trial court. There are a number of legal vehicles for that. But if you can't get the trial court to sort of admit the error and change it, you have to do that. You have to kick it up to the manager. You have to say, hey, appellate body, we've got a problem here. We've got a problem here where we've got this result. This result was reached improperly, and we need to correct that. We need to take a look at this and decide that it was improper and kick it back down and flip it or at least try it again and get it right this time.
So when you're trying a trial the first time, are there things that you want to preserve here just in case it doesn't go your way?
Absolutely. As you mentioned a couple of times already, it's an adversarial process, and it's important to keep in mind that the system is built upon that foundation, that the two parties are butting heads and that they are conflicted over all of this stuff. So when one party makes a move or does something that does break those rules, it's really on the other party to stand up and say, whoa, rule violation, and sort of referee the other party, right? The judge is acting as an intermediary, but they're not gonna call the fouls, right? Their job is to, govern the whole process. It's the adversary's responsibility to call that out, and what we call it is preserve that error for the record.
So do you object to things? Is that how it happens?
That's exactly how it happens.
Okay.
You see something happening and you stand up and you say, I object, just like you see in those court shows. And you explain the objection. The court generally will let you get a little bit of back and forth going between the other attorney while you try and clear it up. And then they'll make a call. And if that call's wrong, the only way to deal with it is on appeal.
And when you appeal a case, is that the only thing they're really looking at? They're looking at the record, they're looking at the objections, and they're basically judging the case on whether the objections or the record are correct?
Yeah, because what we're talking about, essentially, because what we're talking about when we're talking about, for instance, a jury trial, is we're talking about a fact finder that the appellate court or even the trial court can't invade the purview of, right? They can't get in there and say, well, the jury should have seen this fact as this, should have seen it this way. I'm sorry, I forgot for a second we were on the radio. And so,
That's okay.
Should have, looked at it a different way. The court can't do that. It can't jump into the jury shoes and change the way that they got to the result they got to. All it can do is look at the legal procedure and say, hey, yeah, the jury wasn't given the information in the way it should have been given, so that's an unfair result.
Okay, real quickly before this show is over, is there any circumstance in which the appeals court can look at all the facts again?
There certainly are different standards of review available, and sometimes they will look at the facts to determine things like the sufficiency of the evidence and whether there was enough evidence for any jury to find that these facts were even there, right? But that's really all they can do. They can't, as long as there were facts going both ways, they really can't come in and say, well, it was this way over that way. No, because all of that stuff, the credibility determination, trying to take one witness's word over another, if there's evidence that could support any rational person finding it one way, and the jury found it that way, the appellate court can't really step in and change
You're just
that.
out of luck. Got it. Okay, we're at the end of this segment. Francis, one more time, we're end of the segment. This is the end of the show. My time flies when you're having fun. Who would have thunk it that the law can be fun and exciting and interesting? Francis, give them some contact information for you real quickly.
So again, I'm Fancis Dixson. I can be reached at francis@dixonlaw.com, FRANCIS at DIXSONLAW.com, or by phone at 678-214-7700.
You're listening to Lewis on the Law. My name is James Lewis, and it has been yet another fun and exciting show. Thank you, Francis, for being on with me. We have been talking about trials and appeals. I have to, before I leave, I have to give a shout out to the guys who are making the dream happen. That's right, the guys who are making the magic happen here. And I called him the villain of video last week because that's what he is. He's a villainous guy. If you saw the beard and the shady look in his eyes, you'd agree with me too. Anthony Cook, our multimedia producer, thank you for making it happen. And the soothsayer of sound over here, Mr. Sam Davis. He's pushing the buttons, turning the knobs, making it all happen. Thanks to you guys for making this show happen. You're listening to Lewis on the Law. I will see you guys next week.